6:33 coming up towards 6:34 in Trinidad and Tobago. Well, two high-profile matters consumed national attention at the Magistrates Court in Port of Spain on Monday, and indeed many people were of the view that it was much ado about nothing as far as the process was concerned, because all of the cameras were there and people there reporting live right on TV6 and other stations and so on, and in the end it was all pretty straightforward. But in both cases, attorneys use interesting strategies to benefit their clients, and it's always sometimes a bit confusing for many of us on the outside looking at from a distance how these things operate and what happens next. Well, attorney at law Martin George is here to give some insight. In fact, he's so much in demand that he couldn't be on time yesterday. So yeah, I'm putting that out there. He was in another place and they was providing such vital information that they didn't want to let him go. So thankfully he's with us this morning. Mr. George,
yes. Thank you, Fazir.
Good to have you.
Good morning to you and good morning to your viewers, and my apologies for yesterday.
No problem. I mean, we know it works. This is a competitive media environment.
As you realize, I'm working my way up.
Thank you very much. I don't think CNC3 appreciates that at all. I suppose the next step will be CNMG to the very top, just in time for the big
for tomorrow. The exchange.
The exchange that will be happening tomorrow, and who knows, you might be one of the questioners. You never know. But let's talk about what happened on Monday, dealing with the Dana Seethahal matter. First of all, the 11 charge appearing. Anything unusual about the process? Was it all pretty much straightforward as you anticipated?
Well, I would imagine it ran fairly smoothly in terms of the actual process, separate and apart from the inconvenience to all the other members of the public. But in terms of the comments that were made afterwards, and I think even in the court by the attorneys representing most of the accused, where he said that there was the issue of pre-trial publicity and that his clients would not be able to get a fair trial. That I found quite interesting, because it did appear, and I mean I say this with the greatest of deference and respect to the attorney, it appears a bit premature, I would think.
First and we're talking about Kristen Williams,
yes,
the
that's
attorney.
Right. Yes. First of all, Fazir, we're not yet at a trial stage. This is simply the preliminary inquiry. So the question of pre-trial publicity, does not really arise in that sense.
Just explain that for me, because some say that it does right now, because we are in the pre-trial stage, and there's a whole lot of publicity, a whole lot of comment about the matter.
Let's break it down. You see, people bandy around the terms without getting to the root of it. The whole basis for any argument about pre-trial publicity would be that it has the potential to unfairly bias the person or persons who are to make the decision. Now, it applies much more at the trial stage in the High Court, where you are in front of a jury, where you have 12 ordinary citizens and 3 alternates, and they are much more susceptible to the question of being influenced, as opposed to a magistrate who's an experienced judicial officer who knows all the cases dealing with negative publicity. So therefore, as judicial officers, you are trained not to take those things into account in your decision. So to say that there's pre-trial publicity, the only way you can make out such a case is if you are suggesting that the presiding officer there, which would be the chief magistrate in this case, is susceptible to that.
Maybe he is?
Well, the point is you need to set a very high threshold. So let's look at what the cases say. In the case of Nankisun Budram versus Attorney General, that's our former friend, as we knew him, Mr. Dole Chedi.
Yes.
All right. When he was put on trial, he challenged the process because he said there was negative pretrial publicity affecting his matter and that he could not get a fair trial. So it went to the Court of Appeal, and it eventually went all the way to the Privy Council. And the learning that came out of that matter is that, look, the test for pretrial publicity as a bar to prosecution is that you must show it is impossible for you to get a fair trial. Not that it's difficult, or not that you have to put several safeguards in place. You must show impossible possibility of getting a fair trial. So that standard is extremely high.
It's almost impossible. How do you prove that?
How do you? It's almost impossible to prove the impossibility of getting a fair trial. So that's the reason why. And the Privy Council said that it's possible for the court, the judge, to use all means at your disposal to guard the jurors against the effects of it. So sometimes you have the jury being sequestered, they put in a hotel, so therefore they're away from, public opinion and people's, discussions of the issues. You have other ways of, like, for instance, even adjourning. The Privy Council suggested that. They said, look, if there's a lot of negative public comment, you could adjourn a matter for a long time, let that die down, and then continue the matter. So even the Court of Appeal, Chief Justice de Labastide, as he then was, he indicated that a court must not abandon prematurely its efforts to secure a fair trial, and it will be derelict in its duty to the prosecution if it were not to try to proceed with the trial and put all the safeguards in place. So at this stage, while it's a very nice sound bite for the attorney representing the accused to make, it really has very little applicability.
But in that case, Mr. George, isn't that, an attorney uses whatever strategy he devises to best represent his or her client. Could it not be that just throwing that out, even though he knows full well that it's not a jury of 12 ordinary citizens, but it's a magistrate, an experienced person, that by just throwing that out, it creates an element of maybe a little speculation and old talk that might favor his client?
Well, you see, as I say, I think it's premature because, remember, you have to go all the way through the preliminary inquiry stage before you have the question of a committal and before you have the question of them being put to stand trial before a jury. So at this stage, you really cannot realistically anticipate or expect that it's going to affect the magistrate. If you understand me.
In essence, that would sound like a false start.
Yeah, it would appear so, as I say, premature. I would prefer to use very nice and gentle words.
Oh yeah, you're a legal officer, so you know to mama guy in a very, very subtle kind of way. Yeah. But just give us a sense of the preliminary inquiry process. What sort of, based on your experience, and given that this is a very, very high profile matter, what sort of time frame are we talking about for preliminary inquiry?
Okay, now what I would imagine in such a circumstance as this is that the state would wish to use the paper committal, which again is, a matter that you have to take into account, whereby if you're doing the paper committal, you prepare witness statements and you have the transcripts of the witness statements given to the defense beforehand, if you understand me. So again, the question of pretrial publicity doesn't really come into play because it's not a question of the persons coming and giving their evidence initially. It's prepared in a statement, it's sworn, it's handed to you, and then there's the question of who you wish to cross-examine. You identify which witnesses you want to cross-examine and which areas of their evidence you want to cross-examine. So it really is just legal tussling and wrangling at this stage, and then of course you would have the cross-examination which would follow. Now of course along the way there's a possibility of several different applications for judicial review, or even as was done in the Nankisun Budram case, you can file in the High Court and say, listen, the magistrate isn't listening to what I'm saying, so I am taking it for judicial review at the High Court for a higher determination of the issue. Now, of course, as you realize, he went all the way to the Privy Council and it ended up coming right back to the magistrate because they said, look, continue with it.
Right. But in this sense, the preliminary inquiry, just so for those of us neophytes in the legal business could understand, it's essentially to determine whether there is a case to be answered.
That's right. So at the standard that you use at the preliminary inquiry stage is the question of you look for the proof of a prima facie case. So in other words, has a prima facie case been made out by the state based on the evidence? Now, this is different again from the standard you use at the assizes. At the High Court level, at the assizes, it's proof beyond reasonable doubt. So in other words, the magistrate is really just assessing, sifting, weighing evidence, listening to the cross-examination, seeing what has been discredited. And at the end of the day, you put all of it in the basket. And is there a prima facie case? In other words, are the basic elements met evidentially to match the legal requirements for sustaining the charge? And once that is so, it is normally a routine function of the magistrate committing the persons to stand trial.
Do other matters that may involve the individuals who are now being charged, do they come into the consideration at all? Can they be used by prosecuting attorneys to say, well, you know, XYZ, slap up this person, cuff down this person, beat up this person, so it can be safely assumed that he really attacked this person?
No, you're not supposed to. You're not supposed to.
But
And
you can, but
that's
you
another.
might try it.
No, well, the thing is, legally, you would be able to challenge that. And that's another complication with this matter, because there are the charges under the anti-gang legislation.
Yes.
Now, obviously, I would assume, as a course of prudence, they would wish to run parallel prosecutions. I can't imagine that they would seek to try to mix the two together in one grand prosecution. So I would imagine that they would be running them separately.
You mentioned at the very start of our discussion as to how much inconvenience would have caused for people with other matters in the magistrates' courts on Monday. Again, from your understanding, how much time and space and disturbance is this going to create for other matters in the magistrates' court?
Well, I would imagine that, I mean, and of course I have no direct line to the thinking of the higher ups in the judicial system, but I would imagine that a proper course of action would be to do as we have done previously and have a separate court down like we used in Chagaram.
For the Dolce and the Gang.
Yes, I would think that that's the best way to deal with this, because otherwise it really is going to be a nuisance and a nightmare for everyone, because you saw the level of security that was out there on Monday, and if at any point they drop that level of security and some incident occurs, then of course everyone would end up with egg on their faces. So
right.
I would think that the best thing would be have it removed, have a separate court and deal with it down there, whereby you can sit from day to day to day and just expedite everything.
And before we move on to the Jack Warner matter, are we talking about a matter of months, maybe years in this process?
I would imagine this would be years. Yes.
Because there are going to be, as you said, several different avenues by attorneys.
And in addition to which, let's just bear in mind, you have 11 accused,
yes.
11 persons. So the point is there has to be cross-examination in relation to each one, and the state does not have an easy task here, because you have to make out a case in relation to each one of these persons individually. You
can't just lump them together.
This is the point.
You can't be guilty by association.
That's right, because this is not a question of conspiracy to murder. This is, you have charged them with murder. So you need to make very clear and direct links evidentially, bearing in mind that it's not just the magistrate you have to convince, because this is the same evidence that will be repeated at the high court level, where it's a jury that would possibly be quite skeptical if it is that you are lacking, say for instance, a motive or some connection to show, well, why would these 11 individual persons wish to, execute such a, massive and well-coordinated attack upon a very high-profile member of our society. So I think that the evidential burden is going to be very high, even from the point of view of being convincing to a jury.
Well, it's going to be interesting to see how that particular situation develops, and of course the media will be following it, and everyone will be following it very closely. Also following the matter involving Jack Warner, because just last week the U.S. formally requested the extradition of Jack Warner, former National Security Minister, in relation to corruption charges when he was a major executive at FIFA, and he's obviously challenging that. Give us a sense as to your understanding of what transpired in his matter on Monday.
Okay, well, in terms of Mr. Warner's matter, I quite follow what his attorneys did, what his attorneys said. However, it appears that Mr. Warner, when he got outside and he, was presented with the opportunity, he started mounting his own defense, so to speak. And I think sometimes with the politicians, they don't know when to stay quiet. Or sometimes the hat which they're wearing can be confusing, because I think the way he approached it, it really was from a political perspective, whereby he said that he's going to have them file for judicial review based on basically political bias and interference in the matter. However, the law and decided cases again do not necessarily seem to lend immediate support for Mr. Warner. And I'll draw from, I would think, one of the most high-profile issues in such a matter, the matter of Steve Ferguson and Ishwa Galbaran Singh versus John Jeremy and His Worship Sherman McNichol's Chief Magistrate. So this was Mr. Ferguson and Galbaran Singh against the then Attorney General and the then Chief Magistrate. Yeah. Now, in that matter, they sought to apply for judicial review on the basis of the political interference, alleged political interference. And this again was in their extradition proceedings. Yes. And they were saying that, look, because first of all, you had John Jeremy being a very high profile member of a different political unit, all right, and then they made allegations in relation to certain transactions with himself and the chief magistrate. They were saying that, look, they could not get a fair hearing because of the political interference. So they filed for judicial review. Justice Barrow, as he then was, he refused them leave when they applied for judicial review on the ground of bias or political interference. And it went on to the Court of Appeal, and what was said is that, look, when you examine it, the test you use is what would an objective and fair-minded observer conclude. And they said, even if there's overzealousness on the part of the Attorney General, and I think that's exactly what Mr. Warner is alleging here, right? The court held that even if there's overzealousness, that by itself does not equate to a question of political interference or political bias, because you have to consider whom is it affecting. In other words, it has to be such that it is going to affect the mind of the decision maker, which again in this case now is the magistrate. So the fact that the Attorney General may have to liaise with the US authorities, and in this case they also said it in the Steve Ferguson and Ishwa Galbaran Singh case, the Court of Appeal said it. They said, listen, that is expected because under the treaty the obligations are there. So in other words, you must cooperate given your treaty obligations. So therefore, even if it appears that there's an eagerness or a rush to cooperate, which is exactly what Mr. Warner is complaining about, and it's set out very clearly here in that case, the court held that, look, that overzealousness by itself does not equate any actionable political bias or political interference.
I know a lot of legal rulings and judgments and opinions are based on precedent and previous cases, but can it be argued that for example, Mr. Warner might say, I understand the precedent that Martin George read out this morning, but my case is different. I would have been a government minister, and therefore there's a greater eagerness to get me out of the country.
Okay, great. So let's go again. The next case I would then cite for Mr. Warner and his legal team would be the case of Basdeo Pandey and Omar Pandey versus Her Worship Magistrate Ijeni Espinay and the DPP. In that case, Mr. Pandey was a minister, was prime minister, exactly. Right? So therefore you couldn't get higher than that in the political scenario. And they were charged and the matter was being heard before the magistrate Ijeni Espinay. And again, they alleged political bias and political interference. And in fact, they actually made a much stronger case, and I'll tell you why. They sought to say that the presiding magistrate herself had some link or connection to a political party which may have been averse to their interests. They cited her membership in a group called the Maurice Marshall Foundation. They said that that was one connection, and then they cited another connection being that her father was a member of that other political party. So therefore, they were now making it much more direct. Because remember, as I tell you, you have to look and see all these noises you're making. The question is, the real test is whether it has the potential to affect the mind of the decision maker.
Yes.
If it's not affecting the mind of the decision maker,
all of it's irrelevant.
It's irrelevant,
Yeah.
totally irrelevant. So in this case, Mr. Pandey and Mrs. Pandey, they made a very direct allegation, very direct claim. So they are saying, look, the mind of the decision maker is going to be affected because of these things. And the court held not at all. They said, notwithstanding the fact that she may have been a member of the Maurice Marshall Foundation, and of course, you know, Maurice Marshall was a very prominent
member of the PNM.
member of the PNM, right? And notwithstanding the fact that her father was, you know, connected with the PNM, they said there was nothing to show that she of herself adopted philosophically, ideologically, or in practice or theory any of the ideas, ideals, or motives of the PNM. You see, so still, you see how difficult the
Yes.
test is. So, you know, you come back to the question of the impossibility
Exactly.
test.
Yeah, yeah.
You have to show
So that
the
it's impossible.
impossibility of
Yeah,
you getting a fair trial.
Yeah.
So therefore, even though you may have those connections, unless it can be shown that you are now actually carrying out a political agenda against this person, and you have to demonstrate that by evidence. And in this case, they held that notwithstanding those claims and those connections, no, the magistrate showed no inclination in that regard, and therefore let the matter continue.
We just have about 90 seconds left, Mr. John. We won't
Sure.
detain you like CSC lesson that kept you for almost the entire morning. But very, very quickly, we've heard different opinions about how long this is going to go before even Mr. Warner reaches the point of being extradited, if he is to be extradited. Some saying 5 years, some saying 7 years. Mr. Warner saying, I will be here for 15 years. I don't know what all you're fussing about. We had a situation where Anand Ramlogan, and getting a legal opinion on the Ish and Steve matter, there was a reference to individuals being adequately resourced to be able to seek different avenues of legal alternatives and for want of a better term, obstruct the process. From your sense, from your reading, and we are assuming that Mr. Warner is also adequately resourced based on what we are seeing, is this matter going to take 5, 7, 10 years?
I would imagine that he would seek every legal means, as is his right. And we
indeed,
must understand and respect
He is
that.
fully entitled
It is
to
the right
do
of
that.
every accused person to use every legal means at their disposal. So I would imagine that he would certainly do so, and you would have the matters being ventilated. However, I think that in some of the issues, say for instance, the way he raised it, and of course he's not his own attorney, so I guess he raised it from his perspective.
Right.
But even when his attorneys raise it, I think some of them can be disposed of much faster because we've already built up that body of precedent and learning which can clearly guide us. So in other words, the High Court judge will be able to direct his attorney's attention to these cases and say, hey, listen, all right, address me on these issues first. See how you are crossing this threshold before you can convince me that we're going further. So I think it's going to be a lot more expeditious in terms of the hearing of these matters. So it doesn't mean you wouldn't be able to raise several different legal challenges, but I think they can be disposed of a lot faster because we've already been through that experience before in most cases. Of course, you may come with something novel and show that your situation is unique, but as I said, even when he wants to make the claim that he was a former minister, we have the case also of Mr. Pandey, and we also have the case of Sadiq Bash and Brian Crichton, who were both former ministers.
Time running out on us. I don't have a gavel, but we have to close up
Yes.
this segment. Thanks a lot, Martin George, for giving those perspectives in these two matters. We have the news coming up. We're already running a few seconds late, and then moving to the second hour of Morning Edition.